A really fundamental rule for becoming a judge in India, one that has shaped legal careers for decades, is now being looked at by the highest court in the land, the Supreme Court. And what's at stake here could honestly change the entire face of the judiciary.
So, the big question on everyone's mind is the very path to the judge's bench about to be redrawn? The Supreme Court is seriously considering it, and whatever they decide could reshape the judiciary for a whole new generation of lawyers.
All right, to really get what's at stake, we first need to understand the rule that's at the very heart of this debate. So, what exactly is this 3-year rule?
Well, the 3-year practice rule isn't just some casual suggestion. It's an actual mandate from the Supreme Court itself. It means that after you get your law degree, you have to get 3 years of active, hands-on legal practice under your belt before you can even think about sitting for the civil judge exam. The original thinking was, to make sure judges had practical, real-world experience before they took the bench.
So right now, the journey to becoming a judge has a few key steps. First, you get your law degree. Simple enough. Then, you've got to pass the All India Bar exam. After that, you must complete those 3 years of active legal practice. And only then, after all that, can you take the civil judge exam. It's that third step, that mandatory practice period, that's now under the microscope.
So who is it that's challenging this long-standing system? Well, the case has been brought forward by a group of candidates, and they're framing their fight as a really fundamental plea for equality and just a fair shot.
The challenge is coming from candidates in the disabilities or PWD category, and their argument is pretty direct. They believe this rule, while it might seem neutral on the surface, is actually deeply discriminatory against them in practice.
This quote really gets to the core of their struggle. The petitioners are arguing that they face these huge systemic barriers. Law firms or senior lawyers are often hesitant to hire them. So the big question is, if you can't even get that first job, how on earth are you supposed to rack up 3 years of required practice? It becomes this wall that's almost impossible to get over.
And this brings us right to the Supreme Court's big dilemma. The court is now in this really difficult position of trying to balance these competing ideas of fairness and justice.
You can tell just how serious this is. On January 15th, a high-profile 3-judge bench, which included the Chief Justice of India himself, formally accepted the petition. Now, that's a huge signal that the nation's top court is taking this challenge very, very seriously.
And here is the real conflict laid out side by side. On one hand, you have the PWD candidates making a really powerful case that this rule is just an unfair barrier for them. But on the other hand, the court has a major concern. If they waive this rule for just one group, does that create a new kind of discrimination against every other candidate who still has to jump through that hoop? It's a classic legal tightrope walk.
So, facing this tough situation, the Supreme Court isn't just rushing into a decision. Instead, it's taken a really methodical approach, trying to find a solution that could work for everyone.
So what's the next move?
Well, the court is on the hunt for a middle ground. It's actually reached out for suggestions from 2 really key groups: all the high courts across the country and the super prestigious national law universities. They are essentially crowdsourcing expertise from the best legal minds to find a smart and fair solution.
This timeline kind of lays it all out for us. The case was officially accepted on January 15th. Right now, we're in this seeking suggestions phase, and the date you really want to watch is February 26th, because that's when we're expecting a final decision.
So why are we talking so much about this one rule? Well, because the implications of this case go way, way beyond the individuals involved. This could actually touch the very foundations of our entire judicial system.
So what's really on the line here? A whole lot, actually. This case is about equality of opportunity for every single aspiring lawyer. It's forcing all of us to ask what a fair qualification system really looks like. The decision will absolutely impact the diversity of our judiciary, who gets to sit on that bench, and that ultimately affects the quality and access to justice for every single citizen.
And that leaves us with the final question. And this one's for you. After hearing the arguments and understanding what's at stake, where do you stand? Is this rule a necessary quality check, or is it an outdated barrier? It's a really complex issue, and there are no easy answers.